start up again. Karen Worthington and I were having a conversation about this predictive model and this idea of, I said that we had done a lot of analysis on data and came up with a prediction of whether cases would be cold, and that's how we came up with our list of 500 kids to review. We are predicting those to be the coldest cases, which means we're making a prediction about the future of kids that are in foster care, that they will be hard to place and that they will languish on foster care for long periods of time. And some of our long-term thought processes we'll be happy to talk about a little bit later, but some of our processes and our thinking and some of this research is, we know that one of the things we will want to do over the next year or two is to keep up with these children and follow up, because there's some interesting questions. One of them being, the kids that we predict to be cold, did they really stay on foster care for long periods of time, and was it hard to place them in permanency? In other words, do we have a good mechanism for identifying if a case will become cold? And if so, can we use that in policy now? Can we flag cases early on for new types of interventions so that we can change the course of a child foster care's future? That's one thing we're very interested in. And something I've sort of brushed over quickly is when I was talking about that list of the 500 coldest cases that we identified, and I said that we randomly assigned to review only half of them. And the reason we do that is just like in any other scientific intervention, and when you're doing an evaluation of a policy, you want to have some kids where the intervention is done with some group and some where they're not. So the kids, so that down the road, in 6 months, and in 12 months, and in 24 months from now, we can look back and see those kids that we identified for review and went through this process and deliberated and made recommendations. Did the intervention, did this program have an impact on the outcomes for the kids that we reviewed? Will they eventually be more likely to have a permanency outcome? So there are lots of things that we sort of glossed over that we'll be happy to talk about. We've got 4 more policy issues that we're going to cover. In all of the questions, we can talk about all of this, and you can ask questions to all of the fellows because we'll have a Q&A session at the end. And Karen reminded me that when you ask questions, raise your hand. When we get to the end and have our question session, if you raise your hand, we're going to have a microphone on everybody so that we can make sure that it can be recorded. So we'll go through all that. We're going to pick up with Dorothy Murphy.
Good afternoon. I'm Dorothy Murphy. I am about to retire. I'm supposed to have been retired. I spent 20 years as a child advocate attorney and then juvenile court public defender in DeKalb County. Got pretty much burnt out by that. Spent the last 2 years developing a small family law practice with my daughter, Savannah, of whom I'm extremely proud, and we are Murphy's Law Atlanta. So if anything that can go wrong does go wrong, call us. Tracy, 12 years of age, entered foster care when she was 6. Entered with 4 of her siblings when the 13-year-old and oldest sister became pregnant by Tony's father. It was that child's stepfather. The oldest child who had become pregnant had the baby, and the baby went up for adoption. The children were never placed together, partially due to behavioral issues. One of which was that the oldest child, the one who had become pregnant, was involved in sexual activity with Tracy, and this was orchestrated by the mother and stepfather. The children were never placed together, as I said. 2 of them were adopted, no relatives. Only one relative ever came forward, a 19-year-old, who was interested in Tracy's sister, but not Tracy. One of them that was adopted, the adoptive parent, single parent, will not allow contact. One of them is the one that was involved in the sexual activity, and Tracy does not want to see her and is still very angry with her and has not really worked that out, even though she has been in 12 placements, 6 of which are institutional or residential therapeutic care. She is currently in an institution and has been diagnosed with all the most popular acronyms: ADHD, ODD, PTSD. She's also diagnosed with schizoaffective disorder, history of sexual abuse and gross neglect, suffers from asthma as well as enuresis and encupresis. She's on 12 different medications, or at the time of review, was on 12 different medications, 5 of which were psychotropes. She was on lithium, Abilify, Seroquel, Depakote, and Clonidine, as well as 6 other meds for her asthma and her encupresis and enuresis issues. Good news, lots of transparency in the case review. I reviewed the case in October 2009 and was welcomed into the DFAC's office, was given 6 pretty thick binders to review, and absolute access to everything that there was. Compliance with the 10 points, marginal. No diligent relative search report in the file, although the case manager during our interview indicated one was done. There was an accurate search, but again, the only relative that came forward was a 19-year-old cousin from a nearby state who was only interested in a sibling. Frustrating situation, but very, very representative of what happens to children who are identified with behavioral issues that people can't deal with, and then are diagnosed, and then are basically warehoused, and often go from one warehouse to another. In our review of these cases, we discovered that 54% of children are receiving psychiatric treatment. I do not have the statistics yet, but we will, on what medications these children are taking, but my gut feeling is that there's going to be a strong correlation, statistically at least, to the 54%, because these are psychiatrists who can prescribe meds. I do know that when the fellows met to discuss cases, the many cases that we did, the 200 cases more that we reviewed, medication was a big, big issue. And the idea of being on 5 different psychotropes was not unusual. More good news. Because of this project, the SAG appointed to this case went to the juvenile court judge and had an attorney appointed, an outside attorney. That attorney has met with this child once a month. Prior to that, the case manager told me, and I quote, "I am the only connection this child has to the outside world." One person, case manager. Since the attorney's been involved, she has visited herself once a month. There's been an independent psych eval of this child. Her medications have been completely changed because the psychiatrist that evaluated her said that an adult would sleep for 2 days and not be able to stand up on these drugs. Bad news, it looks like she's going to need institutional care, probably to majority. She may be able to be stepped down to a less restrictive residential placement in 4 years or so. Good news is we can plan for her adulthood. We can foster adult connections already. There is a sister who has been located in a nearby state. There has been telephone contact every 2 weeks. There will be a visit, and those visits will continue. There is a mentor from a prior placement who is visiting this child now on a regular basis. She has been to court for the first time. She enjoyed meeting the judge. And the Medicaid waiver services and the things that she's going to need as she ages out are going to be in place. I'd like to see this for every child. This is something that was done in the early 90s as part of a pilot project under JLJR, and I'd love to see it done again. Advocates for children in institutional care, we need it. Read your AJC from last year, read the most recent ones, and you'll see why.
Hi, I'm Leslie Stewart. I'm a child welfare attorney in Decatur, and I'm going to be speaking about adopted children who have been turned back in by their adoptive parents. In the cold cases that we reviewed, a very, very high percentage of these children involved disrupted adoptions. As the adoptive parent of adult children who came out of the foster care system, I found this shocking, partly because nobody had told me that I could turn my children in. But we all know, we can kind of accept as gospel that children who are adopted out of foster care have some special challenges. However, in this study, we found that 90% of the adoption disruptions were caused either by the children's behavior or by the guardian's inability to care for the children. A frightening statistic, Georgia's adoption disruption rate is twice the national average. We're looking at 8% compared to 3.6% nationally. The failed adoptions that we studied fell into two main categories. First one was that parents were completely overwhelmed. The second is that parents were inappropriate. It's no surprise that the families that deal with these children have enormous struggles, and they have extra barriers to finding and then getting the needed services for these children. A lot of the parents that, whose comments were reflected in some of the DFACS documents reported that they had lacked education on things like attachment disorders and psychiatric disorders. Another issue is that some of these children, as toddlers, may look fairly, regular, but when they hit adolescence, some things kick in, particularly in cases of sexual abuse. Georgia's mental health system is widely regarded as being broken, but this is the same system that the adoptive parents have to use to gain services for their children. It's not fast, and it's not easy to get Medicaid approval for either intensive mental health services or psychiatric residential treatment. Adoptive parents can get worn down as a result. In one of the cases that we reviewed, an elderly adoptive mother brought her children in her car to the local DFACS office and dropped them off and said she was done. She said that DFACS had not assisted her in getting the services that these children needed, and claimed that DFACS had not told her about the extent of the children's needs, and specifically focused on the fact that her highly sexualized son, who had a traumatic brain injury, had in turn molested her grandson. In another case, adoptive parents voluntarily placed several children into DFACS custody after the children tried to poison the adoptive mother, had sex with each other, and killed the family cat. These parents indicated that they were afraid of their children, quite rightly, and they ultimately voluntarily relinquished their parental rights. If adoptive families can get help for these troubled children before the point of no return, the number of future cold cases might be reduced. The second category of adoption disruptions that we saw is perhaps more disturbing. Case reviews revealed that inadequate selection of adoptive homes may have contributed to this. In 10.2% of the cases we reviewed that as far as disruptions went, 10.2% of the cases, the adoptive parents themselves had been the parties who had either abused or neglected these children. One case involved an adoptive father. He'd had the children for 5 years. There was a red flag, which apparently everyone ignored, and that was that he had been completely estranged from his two older biological children. Well, in that case, history repeated itself. In another case, DFACS ran a routine background check when the children came into care, and lo and behold, they found that the adoptive family had prior CPS history. In yet another case, DFACS allowed an aunt from a family that had extensive sexual abuse history, mental health issues, to adopt children very early in the case before the children were adjudicated, I believe. And this aunt, in turn, abused and neglected the children. And this raises a question, at least, about whether the relatively new, diversion policy is implicated. In another case, there was a very loving and a very nurturing mother who died. And her husband, the adoptive dad, said that the adoption had not been his idea, it was all her idea, and he had no intention whatsoever of continuing to care for these children. So, why is the issue of adoption disruptions important in this study? We know that failed adoptions can transform into cold cases. What do we know that will reduce adoption disruptions? National studies have consistently found there's a correlation between fewer placements, and that will lead to fewer disruptions. The average, I think as you saw, was over 8 placements in the study. The record was 42 placements. Also, we know that children who are younger have a lower incidence of disruption. So concurrent planning, as soon as a child comes into care, will assist the child in not getting disrupted. Also, the number of staffing changes can affect the rate of adoption disruption. So in Georgia, we have high staff turnover. We've got a policy of having the adoption caseworker and the placement caseworker, and that might be a contributing factor. One special note, Georgia's budget crisis has recently caused the elimination of some supportive post-adoption resources. Camp Promise has gotten cut, although the state's investment was only $100,000. And since it does cost more than $100,000 to keep even one child in residential treatment, which is where they end up typically after an adoption disruption, we might want to reevaluate our priorities so that we can support the stability of these adoptions. Thanks.
Good afternoon. I'm Diana Rue Johnson. I am a parent attorney in Fulton and DeKalb counties. And the policy issue that I will be addressing is adequate legal advocacy. The story that disturbed me the most of the cases that we reviewed in the Cold Case Project was Jake's case. Jake was removed from his parents, who were married. At the age of 8, he was removed with 2 siblings. The cause of removal was pretty benign: inadequate housing and some medical neglect issues regarding one of the children's asthma condition. Well, as is typical in some of these cases, the parents never really got it together. And there ended up being a non-reunification order entered so that services ended to the parents. Jake remained in foster care. His 2 siblings, defects terminated the parents' parental rights as to the 2 siblings, and those 2 siblings were adopted. There was no TPR ever filed on Jake because he was considered unadoptable because of his behavior issues. So 5 years after removal, Jake revealed in a psychological evaluation that he had been sexually molested by his father and also his uncle. In reviewing the defects file, there was no evidence in the file that the case manager had ever even read the psych evaluation. So this sexual molestation that was revealed 5 years later was never brought to light, and it was never brought before the court. And it was, never included in a petition for extension or for a new deprivation. So there was a lot of case manager turnover in this county. So several case managers down the line, several years later, the culture and defects had changed, and they started to look seriously about finding permanency for some of these kids who were just adrift in the foster system. Because there had been a previous NR and the child was placed outside of the county, there were no visitations going on at that time. So the new case manager, apparently without reviewing the entire file, decided that she was going to re-engage Jake's parents. So she tracked down the parents. And lo and behold, they were still married. They were actually living with, I believe it was the maternal grandparents. And so this case manager's plan was to begin visitation with the parents. They started a home eval on the grandparents' house. Fortunately, there were some safety issues with the house that had to be addressed before any visitation could begin. But her plan really was to start weekend visits and transition Jake back to his family. Meanwhile, there had been no identification of the sexual abuse issue. More importantly, no therapy instituted, and in no way had this been even addressed with the father or the uncle. So to me, this case illustrates some of the serious failures in legal representation that we saw in our cold cases. The representation numbers in Georgia just weren't good. Only 70% of children were represented in the cold cases, and for the statistics that we gathered for who was represented at or before the adjudicatory hearing, 57% of mothers were represented and 19% of fathers were represented. The problem is, there was often no discernible legal activity on the part of any of these attorneys, other than the SAG, who obviously was there putting up the case and writing the orders. In terms of the guardian ad litem representation, we saw very few guardian ad litem reports in the file, and the children were seldom present in court. The other disturbing thing was that guardian ad litem representation often did not continue post-TPR. So at the point when we're getting to the post-TPR adoption efforts reviews, there is nobody at that point speaking for the child. The parent attorneys, that was a disaster. Only out of 214 cases reviewed, we saw one motion for discovery. There were very few witnesses called on behalf of the parents, and we saw almost no objections or amendments to DFAC's proposed case plans. In terms of the SAGs, there were a lot of late orders and expired orders, lots of emergency shelter care orders during cases because deprivation had already expired. And in some counties, we saw that orders were taking almost a year to get signed and filed. There were also a lot of factual inconsistencies from order to order. Things like a putative father might be named or even present at one hearing, and a year later we've got him as unknown identity, unknown location. There was also a lot of factual inconsistency with regard to the parents' progress, and I put this on the parent attorneys as well. Early orders would say parents are making good progress, parents have finished 5 out of the 8 goals, and then further down the line, when it comes to NR or adjudications and extensions further down the line, the facts would say parents never did anything on their case plan. And obviously the most disturbing thing that we saw was that we would have cases where the causes of removal were relatively benign, but then months or years later, something would come up, the child would make an outcry regarding past sexual or physical abuse, and that those issues were never brought before the court. Thank you.
My name is Melinda Cowan. I have a private practice in Douglasville, Georgia. I worked with the Juvenile Public Defender's Office in Douglas County. I've represented parents, I've represented children, both in delinquent and deprivation actions, and also served as a guardian ad litem. The policy issue that I'm going to talk with you guys today about is policy issue number 11, sexual abuse, subsequent sexual behavior, and offending. I want to read you guys some actual excerpts from the children's files that documented sexual abuse in their homes. She had sat naked in her father's lap. She felt scared when men peed in women's mouths. The mother's whole family would get together in a hotel room with all their kids, and they all had sex with the children. Frank's older brother had molested him repeatedly. At a treatment session, he was asked to draw what he felt like on the inside. Frank drew a picture of a volcano. I actually reviewed Frank's case. Frank was unable to speak with a therapist about the things that were going on. But it was ironic that when he was asked to draw the way he felt on the inside, he drew a volcano. I think that after reviewing a number of these cases where we saw sexual abuse in the home, what we saw with that volcano, it came to mind on a number of occasions. Because what we saw is that sexual abuse wasn't dealt with for many, many years. A lot of times, what the children simply had to do was just push it down, go on, and you stuff enough down there. You keep filling up the silo of the volcano. Eventually, it's going to blow. So what do we need to do to help these children keep their volcano from blowing? I think that we've got to realize that when there's sexual abuse in the home, it's not enough for DFACS to just come in and remove the children from the home. That's simply not enough. Okay. What we found in the study, or in our file review, was that 29% of the children were victims of sexual abuse. 12% later had become perpetrators of sexual assault. 17% of the children were placed in DFACS custody because of sexual abuse in their home. What we need to do, or what the recommendations are, is simply, if there is an issue with sexual abuse in the home, you need to remove the child and make an immediate referral for a forensic interview of that child. This is particularly important for 2 reasons. Number 1, that forensic interview should give you treatment recommendations for that child. In addition to treatment recommendations for the child, it should also assist you with prosecution of the perpetrator. What we need to do is avoid premature and unnecessary questioning of these children in this instance and leave it up to the professionals. What we're looking at is really a multidisciplinary approach to stop what's called the ripple effect. And really a multidisciplinary approach is getting the department, getting the attorneys, getting everybody on board to follow up and make sure that law enforcement is being contacted, that everybody's doing their part to make sure that action is being taken against the perpetrator. In a number of cases, there were serious issues with sexual abuse of these children, and there was no mention as to follow-up with prosecution of the perpetrator. It's important that we have that information. Number 1, if there is some sort of prosecution, if the perpetrator is convicted, that helps to put the rest of the world on notice, hey, this guy or this girl has got an issue. Second, as a result of any sort of release from incarceration, a requirement is that there is treatment. What the studies show that if there is not immediate recommendation and treatment for these children who have been sexually abused in their home, what we see and what we get is known as the ripple effect. The victims become the perpetrators, and it continues on and on. There is a way to make a change. There are some things that we can do representing these children to make certain that they get the treatment recommendations, treatments followed through with, and that these perpetrators are in fact prosecuted for the crimes. Thanks.
There are a couple of comments I wanted to make to conclude, and then we'll open it up for questions and answers. But the first, I meant to ask for a show of hands at the beginning, and I neglected to do that. And that is, how many of you are happy that you're not sitting down the hall taking a law school exam? Because we all talked when we all got here early and talked about it, that we're very happy that we're no longer in that situation. But we appreciate your time. I know everybody's very busy, and we thank you all for taking time to come today. The second thing is, phew, we finished, because we are all very passionate about this project and what we do, and we've spoken before and run out of time. And the first time we did it, Pat didn't even get to speak because we ran out of time. So we're all happy that we stuck to our time. Our moderator controlled us well. It's a hard crew to control when we all get together. We like to butt heads in a positive way. Having said that, I am going to offer something I haven't shared with everyone, but if you will notice on the back of the agenda, there are bios for each of us. If you have any questions or want information, I would offer that you can contact any one of the fellows. Look us up in the State Bar Directory, and we're happy to share any of the information from the project. There will be a paper that will be hopefully published, but also that we can share. Probably would provide it to Karen Worthington and then allow you through Barton, however is appropriate, to disseminate that when it's completed, hopefully June. Thank you, I couldn't remember the month. I think those are my only comments. other than the conclusions, obviously you've heard from the fellows on individual policy issues, things that you might do differently or think about when you go back to your jobs and we try to raise the bar and achieve permanency for each and every child in care in the state of Georgia. There are some overall, I will tell you in listening, I realized that my particular issue, judicial oversight, should perhaps go last for this reason. It's the triangle I talked about. There is judicial oversight, but the other 2 points are the department and legal representation. And if we take all the information learned, all 3 of those points are only going to improve. It's going to raise the bar, and permanency for kids can be improved in Georgia. First, we need to ensure that there is a detailed child-specific plan for each and every child aging out of foster care. Second, in order for these children to really transition into a self-sustaining, successful adult, every person that goes to juvenile court needs to advocate and do the best that they possibly can. That includes each of our clients, be it the department or a parent or a child, each attorney, the court, the judicial officers that serve for the court itself, the judges. And third is that every person who comes in contact with a child is accountable for that child. I'll be honest, I've practiced for a very long time. I'm not saying how many years, it makes me old. But having said that, I think that it's easy in any job to figure out how to do what you're supposed to be doing and keep doing your job. Sometimes it takes things like specific stories or looking at files or working on a project to remember to really challenge yourself every day. So I think all of us would just say challenge yourselves and to look at the whole picture and anything that can be done differently to really help for all of these kids. We'll open it up for question and answer. I think the best way is if you have a question, we can direct to whichever fellow dealt with that policy issue. If that works. Tammy, could we maybe do one microphone for the fellows? Is that okay, Karen? Excellent. Thank you. Yes, ma'am, in the pink.
Thank you so much for taking the time to do. Go ahead.
Is that one?
So much for taking the time to do this. I had a demographic question. You were listing the children that were included in the study, and I wondered how many of these children, or the percentage, were part of a family group of kids, if you captured that data.
No.
Siblings. Right.
No. Am I on here? Can you hear me? What am I doing wrong? I'm sorry. Okay, I'm sorry. Sibling groups, we did capture in our file review packets whether these children were part of a sibling group and whether being part of a sibling group was causing a problem with achieving permanency for that case. I don't have that statistic with me, but we will be reporting it. If I recall, we were actually surprised that the number was so low, that the majority of the children that we reviewed of that 214, the reason they were not in a permanent situation was not because they were being held back because they were in a sibling group. That was not the primary issue, but we did capture that and I will report it.
I think it's important to add too that the majority of siblings who were, or children who were part of a sibling group, were not placed with their sibling group. And now with Fostering Connections, we have reasonable efforts to place with siblings. So we just saw a lot of children being separated from their siblings and then creating a problem when they tried to then 5 years down the road place them in the same household because they were like strangers.
And could I tie that into Dorothy's point, which is that was often based on the record because of a therapist recommendation. So that's where Dorothy's point, independent oversight, comes into play as well. Oh, I'm sorry, I'll call for me. Yes, sir. All right, there, good. I'm like, Karen.
My question was about policy number 7, the teen pregnancy defects reproductive health policy. You stated that a lot of the girls that you said their babies now are going up for adoption. Was that because they did something where they harmed the child, or was it simply just because their child is in foster care and now they're aging out?
And that's actually a really great question because I didn't address that. We found the majority of the children of the minor mothers were being taken into care just because the children were deprived and being separated from their mother just because the children were in care. Very few of them were because mother actually deprived the child, and that's one thing that we're trying to educate the state on, is the child doesn't have to come into care. You can ask for funds under 4E for the mother for the child, but yeah, almost all of them that I saw, and I looked at them all because to get ready for this, it wasn't anything mother had to do. And a lot of it was mom's at House of Dawn and she came home late one night. You know, just kind of things that any young mother would do, not anything specific to the child itself. So, or I think one of ours that we saw was that the child, oh no, that was the other case, but we saw one where it was the child didn't sign themselves back into care. So we took the baby, which had nothing to do with that, so.
In comparing the cases that you looked at, is there any substantive difference in those files that are covered under the Kenny A consent decree versus the others around the state, and how the outcomes for the children?
That's an excellent question. Miss Worthington? No, I'm kidding. No, I don't know. Tammy, how would you, I don't think that any of those conclusions have been drawn from this sample of 214 cases. Is that correct?
No, it hasn't, and that is something that we didn't look at. We did do some cases in Fulton, but I don't, that's a good question.
I mean,
I'm puzzled
it is a
with the
good question.
I'm not sure. We're not tracking that specifically because we don't know which kids that would be.
Well, it's just kids in Fulton or DeKalb.
Right, and just
Any child in the custody of Fulton or DeKalb.
Yeah.
And we did review both of those
We did review, but what I doubt very seriously we'll be publishing any results that are county specific because we have so few cases within each county. We really, since we're reviewing our 200 cases, the purpose was to be spread out statewide, and our focus is a statewide sample. We don't have enough cases in any specific county to draw any conclusions. That's not a very nice answer, but unfortunately that's, you know, it would be different if we focused in the metro area or in Fulton and DeKalb County, but we just don't have enough of those cases.
And that's a great question. I said Karen because she knows so much about Kenny A. She talked to us about it, but that's an excellent question.
My question is about policy issue number 10. For the serious problems of legal advocacy, did you find a correlation between the counties that had stopped the legal representation at the adjudicatory stage and the lack of problems? Am I making sense?
No, unfortunately, we were not aware of which counties were continuing parent representation through the life of the case versus parent representation ending at disposition.
I meant to say disposition.
But that is something that needs to be done.
Any other questions?
In your research, did you find that, because as you all were speaking, I know for my county, a lot of these things are addressed. And I know that, you know, we go back and forth sometimes with our DFACS office and ensuring that some of these things are done. Is there a disconnect from what comes from the state office to the local operating offices and what the workers, the people who are supposed to be implementing this, are told that they can and cannot do by their supervisors? Because I think on that, that's where I think that a lot of it comes from.
I think the answer is yes, but
Can I
Ashley's
take
going to
this
make it
one?
longer.
No, I'm a huge advocate of SAG training, and I would say to you that there probably is a disconnect sometimes between maybe state office instruction and local office. But again, on the triangle, legal representation, I think that's incumbent on the SAGs to work with their client to resolve any of those issues to the best that we can. We can't make social work decisions, nor should we ethically. However, you can certainly counsel, advise, and try to come together with the two different positions. It is one agency after all. That would be my thought. Anybody else want to add anything? anything?
Yeah, I think I would add just a few thoughts on that. In our report and in our study, we discovered some stellar, amazing casework. And some of that's going to be included in our report as well. So while we're here talking about what we see as the primary problems and what we would like to see improvements in, we're also going to be talking about some amazing caseworkers who have some really, really difficult jobs and are doing amazing things to place kids. Not all of these, there's a sizable group of these children that even the kids that have already exited care, 40% of them exited to a permanency placement. So there are good news stories in here as well. Something else I'd just like to add is we have also at the end of this project, we were conducting online interviews, surveys with DFACS caseworkers as well as SAGs. And one of the things we're seeing from, we've got about 125, 150 caseworkers that have responded so far. And we're asking them things like, talk to us about some of your frustrations in doing this job, this hard job of trying to find placement for kids that have been in foster care for a long time. One of the themes we're seeing in the responses from caseworkers is that they struggle with a disconnect between state and local policy and changing state policy and how they do their job and work a case and then the state changes direction. So we'll talk about some of the things we're hearing from caseworkers also. So I think it's kind of a mixed bag.
And there are two other thoughts. One was Michelle always says in the last 10 years, there's been great improvement across the board from every aspect. The legal representation, DFACS, case managers, courts, all of that, great improvement. These are the worst of the worst of the worst that we got to look at. So you need to keep that in mind. The other part, I just wanted to comment, one of the reasons that the paper, not only statistically, but won't focus on county by county is because the goal, because this was a DFACS project, I mean, they really endorsed this, was to go to each county individually and talk to them directly about their county. So they didn't hear through through this little talk, oh my gosh, my county stinks. Instead, we addressed it directly with them and said, look, and looking at the 10 points, you don't have court orders, diligent searches, or whatever else is needed to try to fix it at that level and try to make the SAGs aware and the department aware and the state office, because they were also involved in those phone calls. So the goal in the paper is not to look at each individual county, but we did have another process in place to try to do that and really look at the individual counties. Okay. I just want to give one more opportunity. I don't know that there are any more questions. Did any of the fellows have anything, closing remarks or anything that you wanted to add? We have a couple minutes. Just have the microphone or come up here, either one.
I do want to add one thing that we talked about, and I just got educated on because I didn't know that, and I don't know if any of the fellows know that, but Pat here reviewed a case where the child's parents voluntarily surrendered their rights. And apparently, if they voluntarily surrender their rights, the child no longer has, the court no longer has a legal obligation to review the child's case. So when you are looking at, we had a child who had not been to court, his case hadn't been to court in 7 years. So no judicial oversight whatsoever. So I think when you're looking at your cases and you're looking at parents voluntarily surrendering, it may be better to look at consenting determination, because then it triggers court involvement. Because a lot of our outlying counties, which most of you are metro, but are so low on money that they're saying, no, legally we don't have to look at them, we're not bringing them back. So I think that's something to keep in mind when you're doing the surrendering. So, because it happens.
Just a question, just in the research that you all did and looking at all this, did you look at anything about the educational system and how the educational system for these children either failed the children or failed to support them?
Yes, part of our review process was to document some of the educational needs, services, treatment, reviews, special education programs. So all of that's going to be discussed in our report, yes. And a very large portion of our cases that we reviewed, not surprisingly, have a lot of special education needs and have issues in schools and have teacher involvement. And so education issues are huge, and it will be a big part of our story. Dorothy?
Yeah, I just had a quick thing to add, and that is I ended my little thing with a very vague reference to some AJC exposés, and I wanted to tell you that I think our contact information's available. If anybody wants the links to those, the one on closings of state hospitals due to abuses arose from a 2007 investigation by the Attorney General's office. There are huge expose that was done in January of 2009, I believe, in the AJC. It's appalling for state hospitals. The stuff involving private providers has just been done during the last 3 weeks. So you can Google AJC and see about Downing Clark being closed and some of the things that have been going on in private institutions and private residential treatment facilities. Anybody that wants to know more about the JLJR case and what due process came out of that, I can give you the site for that. It's Parham versus JR and JL. But if you want any specifics, please contact me and I'll be glad to email you the links.
We got suddenly quiet.
It is a very quiet group. There's so much to talk about. Do y'all want to do closing or? Okay. We want to thank everyone for coming. I appreciate your time today. Please turn in your evaluation forms. Be quiet going to the elevators for the poor students who are still taking exams. And then watch for communications from the Barton Center or the Supreme Court about upcoming trainings that we might have. Thanks.